This is Salinas versus Texas. Case code is 570 US 178. I have a poster board. I didn't have time to buy one, so this is my poster. I'm gonna read through some of the opinions in a sense, not all of them, because I did that earlier and the video was like 12 minutes. So let's just start off with the facts of the case. This case deals with an event that occurred when Houston police officers found victims who were murdered. They started investigating and eventually traced the homicides to Genevieve Salinas. Salinas went to the police station for questioning. He was not under arrest and had not been read his Miranda rights. He was obedient and answered every question until one was actually asked about whether the shotgun shells found at the scene of the crime would match the gun in his home. According to an officer, he remained silent and demonstrated signs of deception. A ballistics analysis later matched his gun with the casings at the scene, and a witness came out and said that he admitted to killing the victims. He was charged with the murders but could not be located until 15 years later, until he was finally captured. At the trial, a prosecution attempted to introduce the evidence of his silence about the gun casings. He objected, arguing he could invoke his Fifth Amendment protection against self-incrimination, whether he was in custody or not. The trial court admitted the evidence, and he was found guilty and sentenced to 20 years in prison and a $5,000 fine. Question of the case. Does the Fifth Amendment self-incrimination clause protect the defendant's refusal to answer questions asked by law enforcement before he had been arrested or read his Miranda rights? Let's get into some of the opinions and dissents of this case. I'm going to read the first three opinions and dissents, or the first three subject matters. The first subject matter is basic limits of the Fifth Amendment. The opinion of the court is the privilege against self-incrimination is an exception to the general principle that the government has the right to everyone's testimony. To prevent the privilege from shielding information not properly within its scope, we have long held that a witness who desires the protection of the privilege must claim it at the time he relies on it. The dissent on the subject matter reads as: the Fifth Amendment prohibits prosecutors from commenting on an individual's silence where that silence amounts to an effort to avoid becoming a witness against himself. This court has specified that a rule of evidence permitting comment by counsel in a criminal case upon a defendant's failure to testify violates the Fifth Amendment. Second subject matter, invoking the Fifth Amendment. The opinion of the court reads that the critical question is whether, under the circumstances of this case, the petitioner was deprived of the ability to voluntarily invoke the Fifth Amendment. He was not. We have before us no allegation that petitioner's failure to assert the privileges was involuntary, and it would have been a simple matter for him to say he was not answering the officer's question on Fifth Amendment grounds. The dissent. The definition of testimonial includes responses to questions that require a suspect to communicate and express an implied assertion of fact or belief, and that is similarly so whether the question individual as part of his decision to remain silent invokes the Fifth Amendment explicitly or inexplicably through words, deeds, or other references surrounding circumstances. How to invoke the Fifth Amendment. Although no ritualistic formula is necessary in order to invoke the privilege, a witness does not do so by simply standing mute. Because petitioner was required to assert the privilege in order to benefit from it, the judgment of the Texas Court of Criminal Appeals rejecting petitioner's Fifth Amendment claim is affirmed. The dissent. Much depends on the circumstances of the particular case. The most important circumstances being one, whether one can fairly infer that the individual being questioned is invoking the amendment's protection, and if that is unclear, whether it is particularly important for the questioner to know whether the individual is doing so, and even if it is, whether in any event there is good reasoning for excusing the individual from referring to the Fifth Amendment, such as inherent penalization for simply by answering. So yeah, some of the opinions in this sense. I'm going to attach the file to this poster in the discussion board too, just because it's all small and I'm kind of reading fast to keep it under 5 minutes, but it won't be under 5 minutes. So the ruling. The decision was 5-4. The court concluded that the Fifth Amendment's privilege against self-incrimination does not extend to defendants who simply decide to remain mute during questioning. And that is Salinas versus Texas, so...